Today, I'm speaking with Dean McGee, attorney from the Pacific Legal Foundation representing New York-based tattoo company Tiny Zaps and two South Carolina residents in a recent lawsuit filed against the South Carolina Public Health Director and State Attorney General Alan Wilson. The lawsuit alleges that two South Carolina laws, one restricting where tattoo shops can operate and another that criminalizes tattoo placement on a person's head, face, or neck, infringe on the First Amendment right to free expression. I was hoping that you could walk us through the First Amendment arguments in this case and kind of how these two South Carolina laws are allegedly infringing on free expression.
Sure, I'd be happy to. And I'll start just giving a little background on how my clients came across this. Tiny Zaps is a New York City-based tattoo shop. They have one in Brooklyn, one in Manhattan, but they operate pop-ups around the country. And they were pitched on an opportunity in Charleston, relatively lucrative for them, a beautiful city that kind of has the clientele that they seek to work with. They do their due diligence and they are shocked to come across these two statewide prohibitions. And in Charleston in particular, which has a nickname, the Holy City, has more than 400 houses of worship, and four of them were within 1,000 feet of where their pop-up was going to be. And so that shut their opportunity down right there. And that coupled with the fact they do a lot of above the shoulders tattoos, typically small behind the ear tattoos, um, led them to us eventually and to this challenge. And on the question of how tattooing is protected by the First Amendment, I think instinctually people understand that tattooing is speech and kind of a uniquely bold version of speech. You are committing yourself to a permanent form of artwork or a permanent statement, whether it's political or not. It is personal and permanent expression on your body. And I think that's almost more true with something above the shoulders that you can't hide during an interview or when you're at work, whatever it may be. So there's sort of an instinctual understanding of that expression. There are some cultures where it even has religious significance. And both the Ninth Circuit Court of Appeals and 11th Circuit Court of Appeals have recognized that not just the tattoo itself and the person getting the tattoo, but the business of tattooing is protected expression. And I don't want to go off on too much of a tangent, but that in and of itself is sort of its own interesting development in First Amendment law, where the Supreme Court is more and more affirming the idea that just because you're engaged in a professional context of doing something, if there's a expressive speech element to that work, it's still protected speech, even though you're getting paid for it. And I think people understand that with things like artists generally, and we view tattooing as just another form of artwork.
Historically, a standard like this is applied to adult entertainment businesses like strip clubs, for example. I mean, how does analogizing tattoo studios to adult entertainment businesses rather than, standard commercial art studios or pop-ups violate the First Amendment? Are there, reasonable time, place, and manner restrictions at play here?
Well, it's very possible the state could raise that as an analogy in this case as a defense because some of those restrictions have been upheld. But my read of those cases, my recollection of them anyway, is even there, the state still had a burden to show that there was obscenity or something that could be considered obscenity, right? Which of course is one of the rare sort of exceptions to generally accepted First Amendment protections. Or alternatively, that there would be some genuine harm to a neighborhood that the state would have to prove. And what's interesting in the Ninth and 11th Circuit cases, even though the tattooing bans at issue there were viewed by the courts as viewpoint neutral, even content neutral, because because the act of tattooing was protected speech, the burden still shifted on the government to show that the laws were narrowly tailored to achieve a compelling government interest, and they just couldn't do it. I mean, in the 11th Circuit case, in a Florida city, the city cited Jimmy Buffett lyrics about regretting a tattoo as their evidence, and the court, of course, properly said that's not good enough.
you're bringing up the separation and this kind of patchwork of decisions from different federal circuit courts, as well as I'm sure that there have been, trial and district court level decisions that are all differing in how they handle, I guess, restrictive criminalization of types of pop-up shops for tattooing in general, just discussion around protected expression as this being an art form. I mean, how do you plan to, and I know you got into a little bit there, but how do you plan to kind of navigate that patchwork in order to, I guess, center your argument in South Carolina?
We think the Ninth and 11th Circuit Courts of Appeal really have set out the proper path. I mean, we may argue there's a stronger argument in our case that this is one, not narrowly tailored because it's statewide. Those restrictions were subject to, we're talking about specific municipalities that tried to restrict or ban tattooing. Um, these statewide laws, by their very nature, I don't think could be considered narrowly tailored. We do have to address, for example, because you're right, there's a patchwork of cases, including the South Carolina Supreme Court, which held in 2002 when tattooing was illegal and actually criminal throughout the state, that tattooing, because it involved human skin, it was not subject to First Amendment protection and could be regulated under sort of more of a rational basis standard. So we are going to have to address that, but the weight of authority is moving in the right direction for us, and we just want to kind of contribute to that momentum in this case.
What might be some limitations on tattooing that might satisfy First Amendment concerns? I mean, like limitations on the age of customers, for example. How does that play into your arguments in the case here?
Well, our clients have no interest in challenging anything that we view as reasonably connected to the health and protecting the health and safety of their customers and of South Carolina citizens more generally. And that really goes back to that burden shifting analysis I talked about, right? The state has to prove these are narrowly tailored to meet some kind of compelling or at least serious, important government interest. Of course, making sure that the tattoo artists are trained in licensed in manners to, prevent infection, for example, is a standard the government's going to be able to meet. So that's the line we're drawing. It's the line that courts really have to draw too. And we're very comfortable that these two laws we're challenging, these two restrictions are challenging, fall, far from the narrowly tailored significant government interest line that the state would have to prove.
We're talking about Tiny Zaps, the New York-based company, but we're also talking about two prospective customers and, Joshua and Stephanie McDonald, who are seeking tattoos to be done by Tiny Zaps. Why did they decide to get involved in this case, and is there any separation between what the First Amendment right to free expression is for them versus what it might look like for Tiny Zaps as a company? Is there any distinction to be made there?
I don't think there's ultimately a distinction in terms of the types of protections afforded by the First Amendment. It's just two sides of the coin. It's the person, putting the expression on their body permanently, which we talked about, and then it's the artist, creating the image for the customer. So, both are protected. The McDonald's, heard about this potential case through an attorney at our firm, and they were very interested in asserting their rights because they recognize that these laws, as just tattoo enthusiasts, people who like tattoos, have restricted their ability to get the tattoos they want when they want them.
What is the next step for the case? Are they involved in, providing any background into their want and their need in addition to the complaint and why they're seeking these tattoos from Tiny Zap specifically? I mean, can there be an argument made by the state that they could go to a different place, and how might you navigate that?
Well, one thing I do want to clarify is that the McDonald's have only joined in the cause of action restricting the above the shoulders tattoos, because that unambiguously restricts them and applies to them whether they want to go to Tiny Zaps or anywhere else for the tattoo. So that's there, we have Tiny Zaps bringing two causes of action against both restrictions we've talked about, and the McDonald's just joining the above the shoulders restriction challenge.
I have one more question for you, and it's really just about what this case looks like moving forward. I mean, what are the timelines? What are the expectations? And how long do you think it'll be? Is Tiny Zaps able to operate while this is ongoing, or is their pop-up being held off until a court makes a decision?
So the pop-up is restricted. It won't be able to operate until we get a favorable decision. Um, the timeline at this point, we are in the most preliminary stage of this case where we have filed a complaint and served the state. I did have a conversation with lawyers for the state recently. We're in the process of negotiating their time to respond to the complaint. I don't know whether they're going to move to dismiss or answer or take any other action that I don't want to speculate about. But I anticipate certainly, by early September, the state will have responded. And frankly, I'm really curious to see what their arguments are. Our view is that whatever they are, they're ultimately kind of going to be a pretext to, um, because, the state has such a long history of suppressing tattoos in any form they can. So I'm curious to see what arguments they make.
Is there anything about the First Amendment arguments here, or just the general complaint itself, that I didn't touch upon that you'd like to flag for anybody that's looking into the case or reading about it?
I think just to reemphasize that, again, our view and increasingly the view of the Supreme Court and lower courts is that just because something is being done in a professional context doesn't mean that the First Amendment is excluded. Our firm has brought cases, for example, on behalf of doctors and patients who want to discuss severe cancer diagnoses with specialists, for example, but are restricted or prohibited from doing so because of telehealth restrictions. We kind of view all of these as sort of in the same universe of making sure speech is protected in that professional context.
Well, Dean, thank you. I appreciate you taking the time to chat with me today and to tell us more about the case. And we look forward to seeing how it plays out moving forward.
My pleasure. Thank you.